Dear friends, can you draft your own agreement? I'm sure many of you has been asking this question many times in your life, as there are many critical situations where you have to enter into an agreement. But the question that whether I can enter into agreement, if I sign agreement or if I draft my own agreement, whether I can bring the agreement to court, whether my agreement is legally binding or not. So I'm here today to enlighten all of us, or to share some information whether you as a layperson or as a normal individual draft an agreement in respect of even a small issues or small terms between A and B. Everyone knows that our daily life we are entering into contract either by way of verbal or in written. Written means in paper documents. Verbal means, what do I mean by verbal? For example, you are having a discussion with someone and you promise A to say that, okay, I will deliver you this parcel by this week. That's already you're entering into a contract. That means that person A is waiting for your parcel to be delivered as promised. So you are actually entering into a verbal contract. But how about a written contract? Written contract, we have to be very, very careful, because when we are talking about written contract, that means there is two parties entering into a contract, two parties or more, for example. So if two parties entering into a contract, there are many terms will be incorporated into those contract document. So that contract document, once it is stamped and enforceable, when one party breached one of the terms or material terms, the innocent party can drag you into the court to get whatever appropriate relief that he's supposed to get under the agreement. So when there's an agreement, we have to make sure all the terms are entered or incorporated in a proper way, in proper manner, and enforceable, and is valid and did not prejudice or jeopardize any parties. Well, what are the terms that we can look into, or to simplify it in layman term, what are those things that we have to look into when entering into a contract? Especially during this MCO, we believe that most of us, there are certain industry where still are working. So that means they are still entering into a written contract or written agreement, but they might not be have that enough time to refer to their solicitors. So during this period, you have to look into those terms before signing those agreements. Okay, number one, what are the most important thing in executing a contract document? First thing, parties must be identified very clearly. That means if you're entering a contract with a company, then please name the company as the parties in the agreement. Do not just name the directors. The other party might just say, hey, I'm the directors of the company, so why need you name my company? You can just put my name. So if you didn't really bothered about the terms that I said, the identification of the parties, you might just agree. So what are the consequences that you have to face later? So let's say the company where you name the director breach the one of the terms of the contract document. So that means you have to enforce the agreement. But can you enforce under the company? No, you can't, because you did not name the company in the agreement. You only name the director. That means you can only go against the director, not against the company. What are the consequences that we need to face by not identifying a proper parties in a contract document? Like what I've explained just now, if you're supposed to name a company, but just because the director suggested, why not name me, who as a director in the contract document? So when that particular company breached the terms of the agreement, you actually cannot sue the company, because the company was not the parties in the agreement. The agreement binding parties to the agreement. That means only only A can sue B, B can sue A. You cannot sue someone or company or whoever it is who are not named in the contract document. That means though the terms actually are binding or explaining about performance of a company, but when you don't name the company itself, then you have no rights to sue the company. Though you know that you can recover your money from the company, not from the director. That are the consequences that you have to face. That means you cannot proceed with the winding up against the company to recover the money, but you can only go for bankruptcy against the director, in which you have named only the director in the agreement. That's why the identification of the parties in the agreement is very important. So always remember, when entering into a contract, please make sure who are the parties entering into a contract. That means who going to perform the obligations, the terms that incorporated in the contract document. That's one. Number two, what are the terms, what are the non-performance terms that we are talking about here? Generally, when all of us entering into a contract, what we are doing, we are just saying that let's put it in a simple way. When A breach the duty or obligations under this agreement, B has a right to sue. That's it. But that could not be a scenario, a position here. To be more defined, you have to name, at least name few of the breach which you can expect that can happen in a contract. For example, delivering a products, delivering goods. In delivering goods, what type of breach could occur? For example, a delay. That means please name delay, a term which construct about delay. So if delay means how many days the delay can occur. For example, can the delay become 7 days, 14 days or 21 days? What will happen in 7 days? What will happen in 14 days and what will happen in 21 days? So when you separate those delays, you are actually explaining to the other party how serious the delay can affect your production, your management, your income for that particular month or for that particular year. That's how important the non-performance terms to be incorporated in the agreement. Another example for this particular heading is you might come up with a term in a contract document by saying that invoice need to be raised in order for another party to make the payment. But what most important thing that we fail to understand, that when one party going to raise the invoice, when the invoice should be paid, is it within 14 days or within 13 days? So we fail to endure that particular term, in which when you enforce the agreement to court, there is an uncertainty in the terms itself, where you or me or your solicitor or the other party solicitor or even the court will be in confused stage, because the invoice raised did not explain when the invoice need to be paid. So in that case, you have to go back to what is the reasonable time to be paid. So that gives a lot of confusion, interpretation. The interpretation could be wrong. So to save all this issue, make sure when you put the terms for invoice raised terms, so when the invoice is supposed to be paid, is it within 14 days or 30 days? You have to explain this in your terms of your agreement, to avoid all kind of confusion between parties and courts later. Besides that, that is another important point that we have to look into before entering into a contract. The third one, another very very important point that I have looked into in dealing with contract cases is preamble or conditions precedent. What is preamble or condition precedent? That means to enable a party to perform something, the condition need to be fulfilled first in order for you to carry on with the contract. Or preamble. In preamble, you have to explain clearly what is your obligations or your duty, your position in the agreement. For example, if you're entering into an investment agreement, you have to put it clear in preamble or in a opening of the agreement itself that your duty only as an investor, not entering into operation of the company. So how do I give an example? For example, A is actually investing 50,000 in a sand mining project. So as all of us aware, or most of us aware, in a sand mining project, the parties need to obtain few approvals from local authority, government and other local bodies in order to carry on that sand mining projects. So if you are actually entering into operation of the company, you have to make sure whether license has been obtained, other documents, procurement documents has been cleared in order for the sand mining project to be carried out. So in order to make sure all that, you have to be very careful in investing your money into sand mining projects. So if you're only an investor, you have to put clearly in preamble itself that your obligation is only on investing part. You will not be responsible should there's any breach in the part of the licensing, obtaining certain approval or getting some documents before the sand mining project starts. That means if the agreement later to be illegal or void, your position need to be put in a status quo. That means you need to get back your money. So the reason I'm saying this is, if at all you did not define your position, then you can be liable as well if the agreement turned out to be illegal agreement, because you are one of the parties for that sand mining project. Besides that, there's another important thing that we have to look into as well when we are talking about this contract document, which is memorandum of understanding. Some of us might have heard this word, memorandum of understanding. What is memorandum of understanding? Especially during this MCO or during this kind of critical situation where we have no time to enter into formal contract. So for emergency purpose or urgent purpose, we will be entering into memorandum of understanding with the intention of the parties that a formal contract document will be signed or executed in future. Another important part that we have to look into when entering into an agreement, especially when parties are not seeking solicitor assistance. Remember that each agreement must be dated. You must date your agreement. Sometimes when there's a breach, you bring those documents to your lawyer or to your solicitor, then we realize that those documents are not dated. There's no date for those documents. One. So what are the problems that you will face when there's no date? That means it's not dated. So you see, each contract document, there is a lifespan of 6 years from the day the cause of action accrued. So how do we count when the cause of action accrued when there's no date in the agreement? When I talk about date, it's not only the date of the agreement. Certain terms in your agreement also need a specific time. For example, delivery of goods and products. So it need to be delivered within how many days or how many months. A certain agreement just left blank like that. For example, a terms A shall be delivering 100 tons of mask to B company. A shall be delivering 100 tons of mask to B company. So the term stopped there. But actually there is very uncertainty in that particular clause, because the clause need to be certain. How do we make the clause certain? The certainty comes in when the time frame is clearly stipulated in that particular clause. For example, A shall be delivering 100 tons of the mask to B company within 7 days from the date of hereof. That means 7 days from the date of the agreement is signed, we have to deliver the mask. So that is very clear. So when 7 days is not delivered, then you have a right to take an action against him because he has breached the terms of the agreement. As simple as that. The next one, that another important thing, that make sure you stamp your agreement. Why I say you need to stamp your agreement? The moment you don't stamp your agreement, when one party breach the clauses, any clauses or any terms of the agreement, you have no rights to drag him to the court, because you can't use this agreement in the court. The unstamped agreement is not admissible in the court. That means, of course you can stamp it later, but you have to pay the penalty. Even if you stamped it later and pay the penalty, you have to give an explanation as to the delay it was not stamped. The genuineness will be questionable. So to avoid all this problem, the moment your agreement is dated, parties sign, make sure it's stamped for the purpose of legal binding. The last point that I need to highlight here is, do not sign any draft agreement. Well, all of us know drafting an agreement is not easy. So definitely, we as a layperson, we might have few drafts. So we might have the first draft, second draft, third draft. So the final draft could be the fourth one. So make sure you only sign the fourth set of the agreement, not the first, second or third one. The reason I'm saying this is, the moment you sign the second one, you're already legally binding, though that is a draft. The reason I'm bringing up this issue is, I have cases where my client has a set of agreement which he brought to me, says that these are the agreement that I signed and B has breached these terms, so I want to enforce this agreement in court. So I filed my claim into the court, and once my claim is sealed, I served my statement of claim to the defendants, and when it comes for trial and we have to file our bundle of documents, we found it there is two sets of agreements signed. One is set A, which was given to me by my client, and there's another set B, which was produced by the defendant in the court in their bundle of documents. So when we compare, yes, there is some difference. And when we question back my client, when I ask back my client said, oh no, this is the final one, that is draft. But he agreed that in that draft agreement, so-called draft agreement, my client did sign the agreement. That means, though he claiming that agreement is a draft, but he did sign. The moment he signed, he's already bound by the terms of the agreement. So the defendant also entitled to enforce that agreement. So now the question is, which agreement is which now? Which is the fair copy of the agreement? So of course we can argue, I only stamped this, but defendant could have stamped the agreement as well to be used in the court. So there's uncertainty there itself. So if you are entering into a contract with any parties in drafting an agreement on your own, if you're entering into a contract, make sure you don't sign the draft. As I explained earlier, the draft can be used against you in the court.